Hello, my name is Logan Reedy, and I'm presenting to you today my final paper for my EDUC 612 Ethics, Laws, and Values in Education course. I do apologize, my camera is currently broken on my laptop, so I can just narrate for you. In my presentation, I would like to talk to you all about the rights of higher education. In higher education, sometimes we wonder whose rights are at the forefront of our concern. As administrators, staff, and faculty, whose rights do we need to be aware of, and which ones do we need to be tiptoeing around when we're doing our daily tasks? Higher education is designed to cater to the needs of students first. Students are our main concern, our main focus. We need to ensure that they have a safe and ethical journey through education. However, there is one pivotal party that is involved in the students' decision making and assisting them in their journey through higher education, that being their parents and or guardians. However, at what point do we draw the line between a student's right to privacy and a parent's right to know? Principal regards, what are rights anyway? When speaking about higher education, we know that there are many principles in place to ensure every student receives that ethical and safe educational experience that we talked about earlier. In my journey through EDUC 612, I've learned a lot more about educational law and some policies and procedures in place to ensure that that experience can be reached for all students. One major law that comes to mind when talking about this is Title IX. Title IX is a federal law that prevents any discrimination on the premise of sex, gender, or sexual orientation within settings that receive federal funding. Oftentimes, issues that students bring forward regarding either hazing, bullying, are often actually regarded as Title IX situations that were addressed differently or given a different name because the student didn't know any better. This federal law assists students in receiving representation in situations such as these and allows them due process if they choose that right. In my experience, in my role in higher education, I oftentimes direct students with Title IX allegations to our Title IX coordinator, who then moves them forward in the process if they choose to do so. Otherwise, it'll be cited for a school's personal record. Additionally, some other common policies and procedures that I would like to touch on are contractual agreements. So when students sign on to attend a post-secondary institution, they begin a contractual agreement with that institution. These agreements are broken down into multiple different pieces, such as their housing agreement or their lease agreement if you offer apartment style housing, their food service contract with the cafeteria or however the institution chooses to provide them food, and their student loan agreement. The institution has a certain set of bylaws that their authority originates from, dependent on the institution's legal identity. A quote from our text reads, "For public institutions, the source is usually a state constitution or state authorizing legislation. For private institutions, it is usually articles of incorporation, sometimes in combination with some form of state license." My personal institution, we are a private institution, so we form a lot of our authority based off of, Ohio common law and things like that. The reason that this comes up a lot is, specifically in student conduct, students will say, they may have been brought in because they violated part of our student code of conduct, and they say, well, I wasn't aware of that. Well, as soon as they signed on to be a student at this institution, they were responsible for reading our code of ethics and our code of conduct. And that is a contractual agreement that students aren't always aware of. Important educational law that I believe concerns parental or student rights is what's known as FERPA, or the Family Educational Rights and Privacy Act. This law places limitations on an institution's ability of handling records and what can and cannot be disclosed about them. FERPA also has some key factors in it that provide students with pivotal rights. FERPA establishes three main rights for students: the right to inspect their own educational records, to request correction to their records, and restrict the access of their own records. In some cases, even restrict their parents from seeing their records. Additionally, institutions are required to notify students annually of their rights under FERPA, as well as supplying them with a formal complaint process through the Department of Higher Education. FERPA has undergone amendments, one being the Higher Education Amendments of 1992, which excluded the records that are created or maintained by the Law Department Enforcement the law enforcement department of an institution, from FERPA. Therefore, these records are available to be released to local authorities if the need arises. Now, how is FERPA different in higher education versus K-12? FERPA in K-12 schools grants parents of K-12 students the following rights: access to their child's records, the ability to seek amendment to their records, or some control over their disclosure. The difference is that K through 12 students are usually regarded as under the age of 18. So their students are without those rights to their records, whereas after they hit the age of 18, that right is then passed on to the student. So then in my personal experience in higher education, I don't deal a whole lot more with parents having access to student rights, although part of our FERPA process is that students can award their parents the right to access those records if the need arises or if they feel that is necessary. Cases that I've chosen to support my final paper are the U.S. versus Miami University and Sargent versus the U.S. Department of Education. In U.S. versus Miami University, the central problem of this case was that Miami University's local newspaper, The Chronicle, wanted to release a campus crime statistics research paper that included student disciplinary records. However, Miami University said that these records could only be used if personal information was redacted. The Chronicle did not like that, so they took it to the Ohio Supreme Court, in which Miami University was told to release the records anyway. Upon asking another university for their records for the same purpose, the Department of Education got involved, and their decision was to enjoin universities from releasing records that contained student disciplinary records with their personal information. Sargent versus the U.S. Department of Education. This case was brought about by Dr. Charles Sargent enforcing provisions to FERPA. These provisions would prohibit federal funding of an educational institution that has practice of releasing records to unauthorized individuals, as well as a provision to the Privacy Act which would allow that when a person requests access to their records, a government agency is required to provide that person with access, as well as produce a copy of said records. Dr. Sargent was seeking records being held by his medical school, as well as all records pertaining to communication between the Family Policy Compliance Office and his medical school. Both the medical school and the compliance office sought dismissal of this claim, as FERPA does not grant the individual a right to private action. Additionally, the medical school believed they fully complied with Dr. Sargent's request, as it was just not to his liking, as all correspondence between the two offices was done over the telephone and not in written form. Thanks to the lack of support from FERPA, his motion was dismissed, as well as his claim against the Privacy Act due to lack of evidence. Through this project, as well as my final paper, I hope I've been able to inform you of why FERPA is so important, especially in higher education. Some students here, although they're treated as adults being over the age of 18, some students still need that personal guidance from a wiser mind or someone that's been in the game a little bit longer than them to ensure that everything is getting done on time and all records are correct when attempting to move them. Speaking specifically on the US versus Miami University case that I talked about on the previous slide, I deal with this a lot in my higher education role, as a formal process that we have is a student code of conduct transfer paper that needs to be filled out when a student transfers out of here, but they also have an existing conduct case. Therefore, their disciplinary records are transferred to the new institution, so they are not made public, but they are kept private, just navigated across the board so that the student can take these specific information with them when they attend their new institution. I hope that you've enjoyed my presentation. I hope that I've been able to inform you of FERPA's mass importance in higher education and just how it can affect some of our policies and procedures. Thank you. And this is my citations page. Again, thank you. I hope you enjoyed my presentation.